All right. Thank you so much. Good morning, everyone. Thank you for being here. This is really a passion project of Legal Aid Chicago. We are a large agency, fortunately, with the capacity to take on pretty much a wide variety of civil legal matters. And one of those projects that we have created just purely based on need and the availability of pro bono attorneys to contribute to this and who feel just as passionate about this work is our criminal records relief work. And what I like to just kind of proudly identify as part of Legal Aid Chicago services is that because of pro bono attorney help, we are able to really focus on this goal of full representation for every client and to explore every available option. What that means, practically speaking, and for everybody to just keep in mind, is that expungement and sealing is really at the heart of what we do. But while somebody is waiting for the legal process to really have an opportunity for these petitions to be heard, to move through the system, a client has a variety of other issues going on. And a lot of these issues probably can't wait. And so in addition to expungement and sealing, we really try to identify what the client's needs are, what their goals are for seeking relief, and we like to explore other options as well. Sometimes that takes the form of some kind of formal proceeding, like if somebody wants to remove a direct barrier to working in healthcare, there's a separate process for that. But really, the important thing to know is that if a client has an issue that their criminal record is creating, then we will try to address it in a variety of different ways. We don't really believe in this kind of one size fits all thing. We really try to individualize every client's case, but this is really the heart of what we do. And this is a really important part of the process of seeking relief in general and in trying to obtain whatever that need or goal is. So this training in particular is going to cover the substantive law on expungement and sealing of criminal records, and then perhaps more importantly, how to take that knowledge and then take a case from us. And that is what you will be hopefully working towards as a part of this training and expertise you will gain. So if I had to really break the expungement and sealing process down to just summarize it, it's really 3 primary steps. We at Legal Aid Chicago really take the lead in step 1, the records research part. This is really crucial, and it's something that there are other situations or other kind of public forums where people end up filing pro se and may not do as good of a job in terms of the records research as an attorney with experience might. And this is not to say that it can't be done, but the system is incredibly difficult, and record keeping in our county in particular and in the state of Illinois can be less than desirable. There are so many missing pieces of information that eligibility for this type of relief really depends on. And so we take the time to review every client's records, starting with the paperwork that they provide to us. And then we create a case chart outlining each client's eligibility. This case chart is what will be provided to you anytime that you take a case from Legal Aid Chicago. And this is really essentially our summary of everything that you need to know for the purposes of completing the court documents. And it breaks down eligibility arrest by arrest. You use this to then do step number 2, which is completing the petitions. That is what pro bono attorneys who take cases from us really focus on. This is no small task. Even if you have a particularly simple case chart, simple client record, the court documents are less than desirable in terms of simplicity. And really taking this time, taking this portion of a case from us helps us serve so many more people and helps us focus on other issues as well that are related to that person's individual record, and really saves everybody a lot of time so that we can increase our capacity. This is what you will be working on anytime that you take a case. And as you will learn, we also have an automated document creation process now through a web-based application that really takes you through a more guided interview to make this even simpler for anybody involved. Once the paperwork is completed, really what it comes down to is Legal Aid Chicago is the attorney of record. We file, we wait, as is most often the case in expungement and sealing cases, and we represent that client in court as needed. A court date is not always assigned, but when it is required, we represent each client in court, which is really an important part of this entire process because, as I will discuss, this can take a long time, and for clients to advocate for themselves pro se can be extremely challenging. So I bring up this particular statistic for a couple of reasons. One, of course, is to explain to anybody who's jumping in on this project to provide any kind of help, is to really show how important this is and how many people this affects. We do this because in addition to the vast need, where in Illinois alone, 3.3 million adults alive today have been arrested or convicted of a crime since 1979, which is staggering, we have to also point out what we call permanent punishments, where once that individual has theoretically finished their obligation to the criminal legal system, they continue to be punished in the form of barriers, laws, and all of these collective punishments or impositions that limit their need to access some fundamental things like housing, employment, and education. And the number of unique permanent punishment laws and restrictions that are on the books in various forms are well over 1,000. So for somebody who has been arrested, it can already create barriers just in that arrest alone, not even really factoring in what happens if that person has multiple arrests or ends up in court. I have to make this distinction between arrests and convictions because it's important to understand that arrests and convictions together create a criminal record. A criminal record is created whenever you are arrested. This is often a really surprising fact for people because there's plenty of situations, especially when past clients have been very young, where they've said, oh, but mom and dad picked me up, nothing happened, I never went to court. Unfortunately, a record is still created every time you are arrested, and it does not necessarily go away automatically. You have a criminal record even if you never went to court or were never found guilty in a case. And for adult records, which is what we will be focusing on for the purpose of this clinic and for the purpose of the vast majority of cases that we get, adult records are publicly accessible records. Once you turn 18, any arrest that occurs 18 and older becomes publicly accessible information. And this is contrary to juvenile records, where these are arrests and cases that occurred when you were under the age of 18. There are some general exceptions to this because of how the laws have changed about when somebody reaches the age of adulthood. However, generally speaking, juvenile records are arrests and cases that occurred when you're under the age of 18, generally speaking. And technically, they are automatically sealed and it's confidential, and there are punishments in place for those who unlawfully disseminate juvenile records, but this does not make them less important. The vast majority of cases, the highest volume of cases that we get are these adult records, but I do not want to undermine the importance of juvenile record expungement as well, which is something that Legal Aid Chicago spends a lot of time doing for any client who has a juvenile record or an arrest that happened under the age of 18. I mentioned the importance of records research and mentioned that the record keeping in Illinois and Cook County is a little less than desirable. This is part of the reason. We need to determine what the outcome of each arrest is, and almost half, about 44% of any kind of publicly accessible record has that kind of disposition information. So what we're talking about is we ask a client to obtain a copy of their rap sheet, their criminal history, and that is really our starting point. When I review a rap sheet, there is so much information that is missing. There is regularly incorrect information, missing disposition information, conflicting arrest dates. There are lots of things that are just amiss, and that is why it is so crucial for us to cross-reference rap sheet data with court records in particular to get the most accurate and official case information. What we are really trying to figure out here is across these three in particular platforms, what exists about our client? If it exists, we are going to try to address it. You would think, and it's a really common misconception, that with an Illinois statewide police report, which is one of the records that we review, that this would include everything in the state of Illinois that this person has ever been arrested for. However, in practice, what you learn is that not everything is required to be forwarded to the Illinois statewide police. Similarly, on a rap sheet, and the distinction here is that a rap sheet comes from a local law enforcement unit, any system, any law enforcement agency that uses a particular system that Chicago uses, which is iClear, it is this kind of unified system of tracking arrest data. That might be included on, say, a Chicago Police Department rap sheet, but it might be missing disposition information. And for any other law enforcement agency that does not use that same system, that arrest will likely not appear. So we try to see if that arrest is appearing on an Illinois statewide police report by chance. So we cross-reference those two first whenever both are provided. We will take one or the other depending on what that client can obtain. And then we cross-reference it with the clerk system, which includes theoretically the official court record of what actually happened. I only say theoretically because there are situations where there is still missing information in the clerk system, especially for older cases that have not been electronically scanned and uploaded to that system. However, it is still an official court record. We can just double check in certain situations that there is unclear or missing information. We can double check by actually trying to pull a physical court file. And often we have to do a little bit more than that, especially for older cases. Our staff attorneys regularly file FOIA requests to try to track down a bunch of missing disposition information. So there's really a lot of work that goes into just making sure we have the most accurate information. Why do we go through so much trouble to do this? And we spend so much time on the records research. We need to track down the outcome because the outcome matters in terms of what the highest form of relief a client can receive. For this slide in particular, let's focus on what we're really looking for. We are looking for the distinction between a conviction and non-conviction. Anytime that we're doing the records research, that is what we are trying to ascertain. Non-convictions are not necessarily just a finding of no guilt or that the charges were dismissed. As anything with anybody with legal experience knows, it comes down to the fine print, and there's all sorts of technicalities that can actually make even a finding of guilt a non-conviction. For instance, if somebody was sentenced to supervision and completed everything satisfactorily, did everything that the court asked them to do, by law, that will no longer be considered a conviction. So what this really highlights is we're not just looking for guilty, not guilty, dismissed. We are also looking for the specific sentence that could afford somebody a higher form of relief. Because as I will make the distinction, expungement is really this kind of gold standard. This is what everybody is looking for, and sealing is really second best, and it's only available for convictions. Expungement is only available for non-convictions. So we often have to really make this distinction, not just for ourselves in determining eligibility, but to our clients as well, who, as they move through a very fast criminal legal process, they can agree to things in plea bargains that they may not fully understand the consequences of. They may be told by somebody in the course of that prosecution that, oh, if you get probation, it'll be eligible for expungement. And we often have to tell them, unfortunately, that's not really the case unless it's a special type of probation, as you see in this chart, where there are some more second chance or restorative justice approaches to sentencing that, again, when completed satisfactorily, will not be considered convictions. However, on a similar note, if you do not complete those special types of sentences satisfactorily, those do become technical convictions. The other surprising thing that I always have to point out to people is that, technically speaking, even fines for municipal ordinance violations are by law considered a conviction. The most common things that I see are drinking alcohol in a public way, anything related to the CTA, and general, just kind of jaywalking type situations, including some criminal traffic offenses like driving on a suspended license, where the sentence may not be jail time, probation, supervision. It may just be a fine. And by law, that is actually considered a conviction. And it's important to make these distinctions. The other distinction I will make, as I said, while our juvenile cases are not as voluminous as our adult cases, it is important to know that findings of guilt for juvenile offenses are by law never considered convictions. And the thing that I will mention about juvenile offenses that could be relevant is there are plenty of individuals who come to us primarily with adult offenses, or who think that they only have adult offenses to worry about, who say, oh, but I was arrested when I was 16, 17. As I mentioned, the laws have changed over time, and this age of majority has changed. So it's very possible that somebody was arrested at 16 or 17, but they were charged as an adult. That does happen. And unfortunately, we have to only work with what that person was actually prosecuted with, what they were charged as. So even if they were 17, if there was an adult case, if that person was treated as an adult, we will have to view this as an adult case, and we have to go through the proper channels, either expungement or sealing. One of the reasons that I like to stress that the language that we use, and specifically as we're doing records research and determining eligibility, it's important to make these distinctions between convictions and non-convictions, and to really understand the nuances in a finding and a sentence that somebody might receive for a particular offense, is that it can really make a difference as to the type of relief someone is eligible for, and what protections are afforded by law as to what records can be seen and considered for things like employment. So generally speaking, you, by law, should not be discriminated against or have it used against you if you only have non-convictions on your record, if you are only somebody who has arrests on your record. However, it happens all of the time, especially with publicly accessible records, that people don't make that distinction. But for our purposes, we really want to focus on that for finding what the highest form of relief is for a client. Something important to know as an example is, like I said, convictions are generally findings of guilt along with a corresponding conviction type sentence in adult offenses. However, for juvenile findings of guilt, these are called adjudications. It seems like this really technical legalese language. It absolutely is, but it makes a difference in terms of what an employer, what somebody, any entity can really consider or access in terms of a juvenile offense. So this is something important to keep in mind, not something to really stress out about, but it's just something important to keep in mind along the way in case a client has any questions about why something is considered a conviction or a non-conviction. So, like I mentioned, the highest form of relief that we are seeking in this process is expungement. This is essentially the complete obliteration of the record as if it never existed. Legally, it will not exist and records will be destroyed. This is only available for non-convictions. And this is the only remedy we seek for juvenile offenses because, as I mentioned, juvenile offenses are never considered convictions. The clerk will impound a file if there's a court file. It will only be available by by court order in the future. And let me tell you, those are very difficult to obtain. Once they get impounded, they go off, live on a farm somewhere. They're in this magical warehouse where things disappear. So it can be very, very difficult to undo this process once it is done. Generally speaking, no private or public entities can see expunged records, and they should never be considered. Sealing, on the other hand, while the second best remedy, I like to take a glass half full approach and stress that even for those convictions that were only eligible to be sealed, because convictions are only eligible to be sealed, even though those records are still available to law enforcement, and there are some exceptions as to other entities who could see sealed records in the future, generally speaking, for the average client who is seeking any kind of employment, which is the most common reason that people come to us, this will not be available or publicly available for just anyone to see. Sealed felony convictions do have a special consideration when that entity that somebody is applying for employment for is authorized to conduct fingerprint-based background checks. And by law, it has been determined that they have a special interest in making sure that they understand who is potentially employed by them, in particular when working with more vulnerable populations, like if somebody's trying to work for a school, financial institution, or healthcare, that entity could still see and theoretically consider this record. It is just something that we have to make sure that somebody understands. If, for instance, their main purpose in trying to seal a conviction that they have is because they would like to work for Chicago Public Schools, we like to be very upfront with everybody and just making sure they understand who would be able to see this record, who wouldn't. There are some technical exceptions with regards to sealing in particular, which is why it makes it the second best remedy. But generally speaking, this can accomplish what a client wants overall for the most part. I do want to briefly touch on some alternative forms of relief, because expungement and sealing may not be an option for everybody, or it could be a less than desirable option. There are wait periods and wait times to contend with. There are ineligible offenses for expungement and sealing, and there might be some more direct statutory barriers that we can overcome in a more direct way. For instance, the most common alternative form of relief that we do is called a healthcare waiver. Healthcare waivers apply when there is an individual who would like to work in a position that requires them to register with the Illinois Department of Public Health Healthcare Worker Registry. These are certified positions, not licensed positions. So for instance, if somebody would like to work as a certified nursing assistant, they're required to register with the Healthcare Worker Registry. And the Illinois Department of Public Health has a list of what they call disqualifying convictions, where if you have one of those types of convictions or multiple convictions of those types that they list, you have to submit a healthcare waiver, essentially explaining what happened, contextualizing what happened, getting things like letters of reference, and really putting together this essential mitigation packet of why you would not pose a threat to patients and why you should be given this waiver to allow you to register with that healthcare worker registry. Healthcare is a really great, lucrative field. The jobs are in high demand. So this is why it is the most popular form of alternative relief. However, there are other similar forms of relief that we could explore as well. If a client has a specific question about that, these are generally the lists of what we do, but specific concerns can be relayed to us if you cannot figure it out through the training provided. And it's just something to be aware of, that we can explore other options. We do handle just about anything in terms of criminal records, and we will consider it at the very least. I happen to briefly mention wait periods as a reason why somebody might need to seek an alternative form of relief. The reason being is that while juvenile offenses only really have one wait period to contend with, which is a 2-year wait period, and that is considered on an individual basis and won't affect anything else that you have on a juvenile record. They'll just consider that for a finding of guilt in a felony or Class A misdemeanor case. That is something that you have to wait 2 years for from the termination of that sentence. Adult records are where this gets really complex. By far, the most impactful and the most frustrating wait period that our clients have to deal with is with regards to convictions. It is a 3-year wait period to seal convictions from the completion of the last sentence of that person's last conviction. What that means is somebody who has multiple convictions on their record cannot seal any convictions on their record if they are still in a wait period based on that very last conviction that they have. So for instance, let's say I was arrested back in 2000, some drug possession or something of that type, where I received probation for a year. I never did anything about it. I just served my probation and that was the end of it. Then let's say 2020, I get arrested and prosecuted and convicted again of another similar sentence and receive 2 years probation. I will not be eligible for sealing of any of my convictions, including that really old conviction, until 3 years after the completion of my sentence for that 2020 conviction. So let's say I finish in 2022 with my probation. The date that probation is over, that is when the clock starts ticking for that 3-year wait period. That can be a very long wait. And if somebody's trying to find jobs, if they're trying to find housing, this can be incredibly difficult. This by far is the most common wait period that you will encounter with your own clients as you take cases from Legal Aid Chicago. But other wait periods to just understand are that there is a technical 120, 160-day wait period for stricken off with leave to reinstate and non-suits. Again, this very technical language that the state's attorney's office uses that pretty much allows somebody to reinstate certain charges depending on what's going on in that case. There is a 2-year wait period to expunge most supervisions, again, with that focus on the sentence. And there is a 5-year wait period to expunge supervisions and those special types of probations, in particular supervisions for more serious offenses like domestic battery and criminal sexual abuse. However, I love a loophole. I'm an attorney, of course I love a loophole. That 3-year wait period can be waived if during the last sentence of that last conviction, so if while I was serving my probation, my 2 years probation for that 2020 arrest, if I earned a high school diploma, associate's degree, some type of vocational technical certification, anything that is in this list, and it is purposely broad, then I can immediately petition the court to seal my convictions as soon as my last sentence ends. The most strict part about this and the way that the law is written is really the time frame in which this certificate is earned. It has to have been earned during that last sentence. So even if it is a day after that I did a course in CPR or something, the day after I was released from probation, that's when I got that certificate. Unfortunately, it would not overcome that wait period. Everything else, it can be very general. If somebody is on probation or parole, I always tell them, go take a course. We will find you an online course of some kind, get some type of certificate. The actual certificate that it is very lenient as long as it's a career or academic certificate, and it can really overcome a significant wait period for relief. Some things that are never eligible for relief, even though juvenile offenses are never considered convictions, but adjudications for first-degree murder and adjudications for sex offenses where a minor is still required to be on the juvenile sex offender registry, these are not eligible for relief. On the adult side, convictions for domestic battery and violations of orders of protection, convictions for things like animal cruelty, convictions for sex crimes, specifically those that require you to be on a public registry, and findings of guilt, which I make a distinction here about if you notice, for DUIs and reckless driving. So even if you were sentenced to supervision, you got a special sentence that would make it a technical non-conviction. If you were found guilty for DUI or reckless driving, that is a serious no-no. We can pretty much never get rid of DUIs or reckless driving unless it was a finding of no guilt. If it was dismissed, then we absolutely can, but the state takes these very seriously. Now, I've talked about case charts that we put together. You will have received a case chart as you are assigned cases from Legal Aid Chicago. This is what we're really talking about. I try to color code and exemplify certain pieces of information from this, not because it's of anything that you should particularly focus on, but I like to point out that any information that is on the case chart can be used for the petitions that you will complete for court. All of the information that you need to complete court documents are included in this case chart. If the court petition asks for it, you can find it on this case chart that we provide. You're going to use this case chart to complete adult petitions and juvenile petitions for each client, if that applies to your particular client. If your client does have juvenile arrests in addition to adult arrests, there will be a separate juvenile case chart that is included in the file that you are given. If there is no juvenile case chart, only an adult case chart, that is all you have for that particular client. And so generally speaking, no matter what type of petition you are doing, you are completing general notices, petitions, orders, and presenting, and you're preparing these court documents within our web-based application. So all of this will pop out once you input the information from the case chart that is relevant through a guided interview. The documents can be broken down into the distinct categories and really explained in more detail, which is what I want to touch on briefly. It is important to know some of the details, even though the web-based application that you will be using does most of the work for you. You may have questions once the documents are actually completed and ready for download, and a client may have specific questions. So for notices, one of the first documents that will be prepared in the web-based application, generally what you should know that you need to provide notice to anybody who would potentially have an objection and an interest in expunging and sealing a case. This generally includes the state police, the local arresting agency, the district state's attorney's office, and the counsel for the municipality the client was arrested in. So for instance, in Chicago, that would be corporation counsel, and that is the lawyer essentially for Chicago. Every individual arresting agency gets a separate notice. What you will notice as you complete cases with us is that if a client was arrested in multiple different districts and by multiple different arresting agencies, it might seem like you have a lot of paperwork. Unfortunately, that is the case because every arresting agency, as you will find, is very common, a very common theme as we go through these court documents. Every individual arresting agency wants its own paperwork. So that includes notices. There are generally two types of notices, one that is Chicago specific, because in Cook County's 6 municipal districts, District 1 only includes Chicago. And so that one is already pre-filled for you. If a client was arrested in another district by another police agency, including suburban police agencies, then we provide that notice information that the application will ask for in the case chart provided. So you don't need to go looking it up anywhere. That will be provided for you. If for some reason you see that somebody was arrested in another district, like by Berwyn, and you don't see that Berwyn contact information on a case chart, you can reach back out to us to make sure that we provide that for you. Juvenile records, keep it nice and simple that there is one petition for all. In general, juvenile records are much easier to deal with in terms of completing court documents. And really the main thing to know is that it is just one individual document that is the core petition for the court, in addition to the additional things like notices and orders. It's just good to keep in mind, if you do have a client with a juvenile record, it really is just one petition where you can include any arrest from any arresting agency in Cook County. Once we get to adult records, that is where this distinction is made and things get a little duplicative. So there are two types of relief, as I've talked about. There is expungement and there is sealing. However, in Cook County, we have three types of petitions. There is an expunge no fee petition, an expunge fee petition, and a sealing petition. The only distinction here is purely administrative. This is something that is Cook County specific. We have a pilot program in Cook County that keeps getting renewed that deals in particular with expungement relief of any case that resulted in dismissals, acquittals, and findings of no guilt. If you truly didn't do it, if you were truly not found guilty in any way, then Cook County will not charge you to expunge those particular offenses. That is what goes on a no fee expungement petition. If you got a sentence that is by law technically not a conviction, so for those supervisions and special types of probation, that Cook County will charge you for to expunge, and those go on a fee petition to expunge. And the simplest one, any findings that resulted in convictions go on a sealing petition. I never want to see anything that is less than a conviction on a sealing petition. Anything else should go on a petition to expunge, with that only distinction being made between those dismissals, acquittals, and then those technical non-convictions based on the sentence. You do not need to figure this out. It is good to know. It helps you understand the case chart. It helps you explain things to clients if they have questions. We have made this determination for you. In the far right column of your case chart that you get assigned, it should say expunge no fee, expunge fee, and sealing. We don't just say expunge and seal. We specify exactly what petition that particular arrest should go on. As I mentioned, Cook County has different districts. Specifically, we have 6 municipal districts. So this duplicativeness really extends itself because we need to file in each respective district that that person was arrested in. So if I was arrested just by the Chicago Police Department, all of my arrests are from Chicago, then I file in District 1, which is either at 26 in California or at the Daly Center. But if I was arrested, say, in Oak Park, that is District 4, Maywood. And I would need to file those petitions in any District 4 petitions in Maywood. As I mentioned, a common theme that you will see is that arresting agencies essentially want their own stuff. They want their own paperwork. So in addition to the fact that we have to file in each respective district that a client was arrested in, every arresting agency wants its own separate filing for every type of relief. So theoretically speaking, if I was only arrested in Chicago, I could be filing 3 different types of petition in District 1. So if I had an arrest that resulted in a dismissal, an arrest that resulted in supervision, and then a straight out conviction, I have one arrest that goes on an expunge no fee petition, one arrest, the one that resulted in supervision, going on an expunge fee petition, and then that conviction goes on a petition to seal. It is a bit confusing. I absolutely understand that. But what you need to know is that if the arresting agency is the same and the eligibility is the same, Any arrests that match exactly that can go on the same petition. So any dismissals that happened in Berwyn, let's say, and those go on an expunge no fee petition, those all can go on the same petition. Any convictions that happened and that's by that same arresting authority can go on that same petition. Please feel free to look back at this slide as a point of reference if you start to get confused. We really break down this example for you to try to explain it a little bit better. But really what you need to know is just what's in the case chart, the directed questions that you get asked as part of that guided interview from the web-based application will really help you understand and put the pieces together where they belong in a really helpful way. So it can be helpful to look back at this, but stress not the web-based application actually helps you a lot in terms of sorting what goes on what petition. For juvenile records, again, nice and simple. It's all centralized. We file everything at 1100 South Hamilton on the west side. It is one centralized system and thus one petition that you will download from the web-based application. It is very, very simple to do, and this is automated for you. Something that you will notice in particular on the adult petitions are that the questions, the check boxes that you will be presented with to check all that apply, these are a little bit different than what the final product will actually look like. The reason being is that the actual official petitions themselves have a bunch of these check boxes that you have to apply if it applies to that petition in particular that are very confusing. They barely seem like English. So what we have done in the web-based application is we have translated these for you in a really understandable, simple way so that you just check everything that applies to your specific client for your specific petition that you are working on. So if you're working in the web-based application on a petition to seal in Chicago at that particular moment, the check boxes that you will apply, for instance, one of the check boxes is an offense on this petition is a misdemeanor conviction. If one of the offenses on that particular petition that you are working on is a misdemeanor conviction, you're going to go ahead and check that box. Anything that you potentially need to actually answer these questions is in the case chart. We also have a little section underneath the chart itself that we lovingly call our love notes section. These are notes to you that explain anything additional that you would potentially need to know, including a nice little list of all of the petitions that you should complete, all in summary. It'll break it down for you. For District 1, you're going to complete a expunge no fee and a sealing. For District 3, for District 4 Berwyn, let's say, you're going to complete an expunge no fee. We break that down for you. We tell you any additional information you need to know, any funky situations that come up with a particular client and their particular record. We explain this to you. If we are quiet on a matter, you can assume that whatever that checkbox is asking you to check does not apply. So if we tell you that this client is in a wait period and has certificates to waive that wait period, you can check that box. If we say nothing to that effect, assume it's not true. Now, I've made this distinction between expunge fee and fee petitions in particular, but again, this is purely administrative, and this is actually something that we do not worry about in terms of fees themselves. We, as a civil legal service provider, fill out a Rule 298 certification for waiver of fees, more commonly known as a CLSP. This is part of the automated document application that you will complete. You need to make sure that you complete a CLSP for each adult petition that you complete. So for every single petition, not just that particular district's filings, every single petition needs a CLSP. You need to account for every single case number on that CLSP. There are specific directions in the application as to how to do that. all it is really just copying and pasting those case numbers into this box that the application provides you so that this document is automatically created. And you want to only include the case numbers for that specific petition that you are working on at that particular moment. And juvenile petitions do not require a CLSP because the laws have changed, and everything that we do in juvenile is free. How long does this take? This is the question that I dread when it comes to adult record expungement and sealing. For juvenile record expungement, we typically get a court date about 45 days out after the notice period has run, and we receive confirmation of expungement around 60 days after that. For adult record expungement and sealing, for District 1, for the most popular municipality, we are not receiving responses for 12 to 14 months. That is why if a client has a specific concern that we haven't already addressed in the intake process, you can absolutely let us know. This is something that they most likely have been told upon intake, that if they have Chicago arrest, this process can take 12 to 14 months in terms of just getting a court date. In the suburban districts, however, in districts 2 through 6, the time is a little bit more reasonable and varies from about 60 days to approximately 6 months. What is the benefit of expungement and sealing? What can I say? What do I have to say? Here's the bottom line. An employer cannot ask you about arrests, only convictions, and only after the initial job application process. So while people are waiting for this relief to be hopefully granted, until that point when things are granted, that is the most important thing to know. If everything on that person's record has been expunged and sealed, you may answer no to the question, have you ever been convicted of a crime? Except in those pesky situations with employers who are authorized by law to see sealed felony convictions. I do not like to spend too much time on this, in particular as you are doing initial counseling with your client, because it really comes down to a case-by-case scenario. Employment law can be very tricky, and this is important to just understand that there are exceptions to this, that there are some employers who could see it, and we can talk hypotheticals all day. But if that particular client says, I just applied for a job with Chicago Public Schools, they're wondering how this is going to go, what they should consider, how this is going to affect them, then you can tell them that CPS, for instance, as you are learning from this training, is an employer who is authorized to see sealed felony convictions, and it may affect their employment with CPS. If they have any other questions that you cannot answer from this training, you can absolutely direct those questions to us back at Legal Aid Chicago. In the love notes section, you might see that a client is required to provide a clean drug test prior to filing. This extremely problematic part of the law is still part of the law, unfortunately. And if a client has a drug-related conviction, so this is only talking about adult records, if a client has a drug-related conviction that they are trying to seal, we are required to attach a clean drug test to that filing, and it needs to be a recent copy taken within 30 days of filing. So once you finish counseling your client, when they ask, oh, you mentioned I need to get a drug test, should I go do that now? They can absolutely go do that now. And we are in a pretty good place with filing and can file relatively quickly. So if they get that to us in a timely manner, we can get that drug test and that petition to seal nice and filed, and everything will be good. People ask all the time about cannabis, and in particular, if they should be concerned about the presence of THC coming up on one of those drug tests. Technically speaking, and I will fight to the death on this, if a judge has a problem with the fact that a client who is over the age of 21 has THC in their system and want to use that as a basis for a denial, I will come out swinging. But bottom line is, you may not want to, if you can help it, have THC coming up on a drug test that you're required to submit with a petition to seal, just because judges still have discretion in these cases. I do not have enough information to say like, oh, this judge is cool with it, this judge isn't. It hasn't been done enough to the point that we can say, oh, no judge is considering it. Every judge is seeing that and overlooking it because it's legal now. It's just worth considering, but it is by no means a bar to actually seal, to file the petition to seal. Just understand that it is a consideration because ultimately there's somebody else making this decision. Speaking of cannabis, what are we doing about cannabis? We heard that it's legal, that expungement is happening. The law is one thing, implementation is another. There are now forms of relief that are happening automatically, but the parameters are very narrow and there continue to be gaps in how this is actually rolling out. So what you need to know is that wherever possible, Legal Aid Chicago is taking action on cannabis offenses if we still see them appearing on a client's record. For convictions in particular, we file a separate motion that is called a motion to vacate and expunge. And a client may have something that is eligible for one of these motions to vacate and expunge. We specify that on their case chart, and the instruction that you are given is that please let the client know that Legal Aid Chicago will prepare this motion separately and follow up with that client individually because that is the highest form of relief available for that particular offense. But bottom line, we cannot rely on automatic expungement alone. This is the portion of the training where I give you the CLE code. So if you are one of the people who are interested in CLE credits, it is leaves 21. It should also be in the chat. I'll give you a moment if you need to take it down. Thank you. All right, you're ready to take a case. What's going to happen now? So in a case assignment email, you'll receive a case chart for a client, including the client contact information, a client call checklist, a next steps document to send to the client about what's going to happen once they're done talking with you, and any additional information that is specific to that client. So as I mentioned, if somebody needs a drug test, for instance, we have a flyer that includes the locations of the cheapest drug test places that we could find. You are going to be asked to send these additional documents to the client. If you are uncomfortable sending from your email, please let us know. We can go ahead and take care of that. But I will mention that it is rarely ever an issue if a client after this clinic, after this point in your representation of this, ever were to contact you after this, you could always just forward the email to Legal Aid Chicago. We will happily take it and take it away from you. It rarely happens though. You are going to prepare the court documents using the web application, and that link should be in your assignment email. Once you are done going through the guided interview, you are going to download completed documents from the app. This is very important. Briefly review them, and then you are going to call your client and explain eligibility. They have been told, if you have been given a case assignment, they have been told to expect a call from a pro bono attorney. Please try a few times, especially if you use a caller ID block or *69. Just try a few times, leave a message. If you're really struggling to get a hold of that client, then let us know so we can assist. Once you speak to that client and you explain eligibility, you explain next steps, you're going to email the completed documents back to Melissa at mpicciola@legalaidchicago.org. Essentially, just hit reply to the assignment email that you receive and attach those downloaded documents. Please remember to download those documents. We can't go and fish them out of the app. Please download and email them to Melissa. You do not need to have us review the documents or send the documents to Melissa prior to calling your client. Once the documents are done, that is all you need to do in addition to calling your client. Don't worry about anything else. We will take it from there. But you are going to do the best that you can to counsel your clients and answer questions that they have. In particular, once you have completed this training and you're semi-experts at this point now. Now, with the application itself, as I mentioned, you're going to go to the link provided via the assignment email. You're going to look over the case chart and then use the guided interview to complete the forms needed for your client. Then again, I will stress it again, please download the completed PDFs so that you can send them to us. And once you finish calling your client and speaking to them, you will please email the completed PDFs to mpachola@legalaidchicago.org. And if there's anything relevant that you need to include as a part of the conversation that you had with that particular client that you could not answer, especially, please just include a brief summary of that discussion with the client and any questions that you were unable to answer. There are a couple of tips and tricks that I want to share that will be helpful. These are some of the most commonly asked questions, so we try to make sure that we address these head on. One case can have multiple case numbers. Include them all. So when you get a case chart, each row is its own separate incident. Everything that happened in that particular arrest, in that particular incident, is in that row, including sometimes things like multiple case numbers, multiple counts, and even sometimes multiple arrest dates. For multiple case numbers, the reason that this happens is usually because somebody has been indicted for a felony. When you are first assigned a case, essentially, a municipal case number is created, which is just this basic 98176543321. If you are indicted for a felony case number is created, or a CR number, and that is usually the year that the case occurred, the letters CR, and then a bunch of numbers. That is why there is sometimes duplicate. There are sometimes even more than 2 case numbers. This happens for a number of reasons, but we try to organize everything in the case chart in a way that directly corresponds to the petitions as you will be asked to complete through the web-based application. If for some reason there is a 3rd or 4th case number in that row, because the web application has its own limitations in terms of character limits, please feel free to use another row. If you have any questions or concerns about how to do that, please let us know. But generally, if you identify in your individual case chart that you're going to need more rows than what's provided, the web application asks you at the beginning of each petition or at the beginning of the process itself, how many offenses do you need? How many rows do you need? And you can specify there. The other common question that I get is about one finding of guilt where everything else was dismissed. Generally speaking, one finding of guilt, and so goes the case. There are only very rare circumstances where we can separate those counts from a finding of guilt, and we generally will not bifurcate the case, as it's called. There is a small exception with traffic offenses that some of you might see on your individual case chart, but I have specified exactly how to process those. As I mentioned, the application does have character limits, and in particular, when somebody has multiple counts for that one arrest or case, please include just what you can fit, abbreviate liberally. This is one of the least important parts about the case chart, because when these petitions get filed, they must be reviewed. Every offense needs to be looked up and the charges need to be confirmed. So if that person has 4 or 5 counts and they're all for different things, feel free to just put the first count and then comma et al. That is absolutely fine. If a case has multiple CV numbers, which are central booking numbers, really just another identifying number from a law enforcement agency, or has multiple dates of arrest, this is not a mistake. If you cannot fit additional information into that particular field and are concerned that you can't figure it out or that it's a mistake, please let us know once you are done. This is something that we can add ourselves using Adobe, not a big deal. You can include just the one arrest number, the one arrest date in particular, and we will make sure that we take care of the rest. Please keep in mind that we do review every petition. So if there is a mistake, do not panic. Usually most mistakes that we find are very easily fixable. It is not the end of the world. I promise you're ruining nobody's life here. We review everything, and generally speaking, the web application is pretty good. It guides you through just about everything that you need to know. If you have not called clients before or you do not regularly work with clients, here's a really great checklist of what you should do on the call. You should introduce who you are, what your role is in the process. You can make that distinction. I am not the attorney of record for this case. I am helping and volunteering to prepare the court documents, and Legal Aid Chicago is your attorney. You are going to explain eligibility using the case chart. You do not need to go through every single offense line by line. I generally like to summarize what forms of relief that individual qualifies for. And then if that individual does have specific questions about specific offenses, you can address those more directly, of course. You explain next steps. In addition to Legal Aid Chicago being their attorney for the purpose of these expungement and sealing petitions, we are going to review the documents and then arrange for signing, which includes the petitions and some additional administrative documents like a retainer for representation for them to review and sign. As soon as we are able to, we will file their paperwork with the courts. And if a client needs to submit a drug test, let the client know that you will email them the flyer on where to get a drug test. Unfortunately, there is no fee waiver for the cost of that drug test. And finally, you are going to explain how long this process takes from time of filing. Now, as much as I would love for every single petition to be granted because it's eligible for relief, one day, maybe, there are potential objections that come up. Because we do a good job with our records research process, really the only objection that we ever receive is from the state's attorney's office, and it's specifically called a public policy objection. Whether it's through the policy of their individual district office to object to certain offenses, just as a matter of record, whatever they are being told by their supervisor, or their own concerns about expungement or sealing of a particular record, this public policy objection is really this all-encompassing objection where you can essentially just say as a state's attorney, well, the nature of the offense concerns me. It hasn't been long enough to remove the record. I'm concerned about this person being just very dangerous or perceived patterns of offenses. There are a bunch of subjective concerns that come up depending on the assistant state's attorney at the time and what that particular client has on their criminal background. But that is the objection that we do commonly get. We will work with the client to gather any mitigating evidence that will work to help us form our argument against the state's attorney's office. And this might include letters of reference, awards, personal statements, evidence of therapy or counseling. And we generally have a conversation with that client about why this relief matters to them, what they're trying to accomplish, and try our best to overcome any objections that come our way. If relief is denied, you can always petition the court at another time. I mention this because you might have a client who asks, okay, if this is denied, if the worst happens, can I do a pardon? A pardon or petition for clemency is something that we really do not do, largely because most of what we can accomplish is through expungement and sealing. A pardon is really a last-ditch effort, and the amount of effort that it takes to put in is really disproportionate from the success rate. The last statistic that I saw in the report from the Prisoner Review Board, that it was about 5% of all petitions for clemency that are filed are actually granted, which is very, very low. So if a client does have a specific question about, can I do a pardon? Really, you can say it's not something that Legal Aid Chicago regularly does, but you can discuss those options that may exist if a denial happens with them at that point. We don't want to create potential anxiety or additional problems where there aren't any yet. Hopefully, and most commonly, we do and can overcome objections that come up in court. We also get a lot of questions about FOID and concealed carry. The reason being is, well, there's a lot of reasons, but one of the most popular reasons is that there is a really lucrative field in security. And for a lot of security positions, to get that elevated position, that more high paid position, a security agency may require that that person is eligible to get a FOID or concealed carry card. What to know is that sealed felony convictions, in particular, the things that would really restrict somebody from a FOID or concealed carry, are still accessible by the Illinois State Police, which is the entity that regulates FOID and concealed carry applications. A felony conviction can absolutely prevent you from obtaining a FOID or CCL, even after sealing. And our advice, generally speaking, is that particular client does have a right to appeal. They can explore the appeal process directly with the Illinois State Police. If they have applied and have been denied, again, there's that appeal process and other administrative processes in place. But we personally do not assist clients with applying for FOID or concealed carry. If they are seeking a firearm for employment purposes, we may be able to help provide some advice on a case-by-case basis, but we're pretty limited in our expertise in this field in particular, and we can certainly make some referrals. Generally speaking, especially if you are new to criminal records relief, there are just a couple of things to keep in mind. One is that this is, even in your limited capacity as a pro bono attorney working on one of these cases, this is some place where you still need to earn some trust. This can be a really sensitive topic for a lot of clients. This can be a source of embarrassment. This can be a source of anger because of how they were treated and that person's experience with the criminal legal system. It's important to just keep your eye on the prize of what the goal is here. Make sure that you stress to a client that this is not a place of judgment, some place to place blame or to challenge their own personal account of anything that happened. We really are just trying to provide relief in this limited context, and that this is essentially a safe place with us to be able to express some of those things. But ultimately, you have to manage expectations as well. These forms of relief are discretionary. There is no inherent right, in particular to adults, expungement and sealing. And so we cannot guarantee a positive outcome, but we will do everything we can to advocate for that client as zealously as possible. If a client would like to get in touch with Legal Aid Chicago, they will have contact information on the next step sheets, but here is additional information as to how they can get a hold of us. Specifically, if they need to send us any kind of documents for some reason, there are multiple ways to get information to us, including they can send a picture text message to us. If that is something that applies to your client, please just let Melissa know by emailing her at mpachola@legalaidchicago.org so that we can actually arrange for that to happen. You do not need to have the client send anything before you start working or make any changes based on anything new that they may submit, such as, oh, I got a more recent copy of my rap sheet. Just send it to us or instruct them how to get those to us, and we will follow up.